If you disagree, then prove it. Debate me and let the people decide.
I'm unafraid to say what I think. And whether you agree with everything I say or not, know that when I...
Good evening and welcome to this evening's Legal Hour with myself, Raheela Hussain of Greenfield Solicitors on Ben TV. Today's date is April 28th and this evening it is a live show with myself. You can give me a call on 0208 808 0693 and I'd be happy to answer any questions that you have on immigration and human rights law. As I've said, my name is Raheela Hussain. I am the Principal Solicitor of Greenfield Solicitors. Greenfield Solicitors are a firm of specialist immigration and human rights solicitors. We specialise only in UK immigration and human rights law. I'm a practitioner with about 13 years experience as a solicitor specialising only in immigration law. Please do give me a call on 0208 808 0693 and I'd be happy to answer any questions you have on immigration law. I should also let you know that the information I provide today is just that, information. The information that I give in this evening's show should not be relied upon for legal advice. If you would like to have a consultation with myself, please do give me a call on 0208 884 1166 and any of our immigration team at Greenfield Solicitors will be happy to book you in for a consultation with me. So for this evening's show, I'd like to touch upon a subject which I spoke about during my last show a couple of weeks ago on Ben TV. In the last month, in April 2015, the Home Office have introduced something called the Immigration Health Surcharge. Now, as I touched upon during my last show, what this effectively means is that the UK government are seeking to recover funds that migrants utilise when using the NHS services free of cost. At the moment, there is a debt of over £1 billion owed to the NHS as quantified by the UK government. And as such, on April 6, 2015, the UK government said that from now on, whenever a migrant makes an application for either entry clearance, leave to remain, or an extension application for more than 6 months, then the migrant must make a contribution towards potential NHS costs for the period that they will be in the UK. Now, it's quite baffling, in my opinion anyway, to try and quantify how the government have assessed how much a migrant should pay for services with the NHS. At the moment, it would appear that under discretionary leave to remain, which is now granted for a period of 2.5 years most commonly, a migrant would need to pay £500 for the 2.5 years if they are granted an extension or leave to remain in the UK for discretionary leave. The fee of £500 is for the immigration health surcharge alone and does not represent the Home Office fee, which is separate and which the Home Office accept for the processing of the application. Currently, applications for discretionary leave to remain are charged at £649. Now, the difficulty here is, for example, where an immigration health surcharge has to be paid for not just one migrant, but perhaps they have dependents. So perhaps they have a wife or children. Now, the immigration health surcharge will need to be paid not only for that applicant, but in addition for each and every dependent applying. So it does not matter if you have a child who's aged 10 or 4 years old, they will still need to pay the immigration health surcharge when the application is made to the Home Office. And as I suggested earlier, anything for 2.5 years will need to be paid for £500 in advance when the application is lodged. The Home Office have said that if an application is deemed unsuccessful by them, that means if they refuse an entry clearance visa, a leave to remain, or an overstayer discretionary leave to application, then they will refund the money to the migrant for the immigration health surcharge only, but not for the Home Office fee. At the moment, there hasn't been much discussion on how they would refund any monies if an application is unsuccessful or when, but this is new guidance that was only published a couple of weeks or so ago. Obviously, this will put migrants in a very, very difficult position financially. First of all, they have to afford the fees for making a Home Office application, which begin most commonly at £649 per person. And again, with dependents, the Home Office charge a separate application fee for processing of the application. In addition, with any legal fees, assuming one was to use a solicitor or a legal advisor to undertake the application, there is also then the immigration health surcharge. As this is a very new introduction, I can't at this point tell you how in practice it will work. So please do bear with me over the next few shows that I will be presenting on the live hour on Ben TV. I will update you as to how we find our clients are dealing with this new change in the immigration law, which is very, very significant. Now, this evening, I would like to concentrate on the subject of immigration appeals. Immigration appeals is a very, very popular topic. Indeed, you or somebody you know has more than likely gone through an immigration appeal before the Immigration Tribunal in the UK. Now, what is an immigration appeal, or when does it come about? An immigration appeal comes about when the Home Office or the British Embassy refuse a visa. Not all visas are eligible for a right of appeal. Only certain visas are. For example, the most common being spouse visas, fiancé visas, civil partnership visas. These are the type of visas that commonly give one a right of appeal if the entry clearance officer or the Home Office refuse to grant that person their visa. Other type of migrant visas only give right to something called an administrative review. So mostly points-based system visas, such as Tier 1, Tier 2, 3, 4 and 5, only give rise to an administrative review, which is not a right of appeal. Now, what I'd like to concentrate on is where there is a right of appeal and a full right of appeal. What does one do if they are refused a visa? Well, the first thing I always suggest, and is a good idea in practice, is for a person to obtain legal advice before they put in any visa application. This is particularly important as good legal advice will ensure that the application submitted by the migrant will have hopefully a better chance of success in obtaining the visa in the first instance. Immigration law is law, and therefore one needs to be well versed in immigration law, the practices, the procedures and how it applies in order to make a successful application. So very, very strenuously, I would submit that you would need to try and get legal advice before putting an application in, and that would hopefully guide you on the right path before you submit an application for be it entry clearance, extension or regularisation of legal status. Now, assuming one puts the application form in with or without legal assistance, if the application is refused, the Home Office or the entry clearance officer will provide a reasons for refusal notice. On this reasons for refusal notice, it will explain why either the Home Office or the entry clearance officer sought to refuse a visa. Now, taking an example, for example, a spouse visa, there is a criteria that needs to be met. Generally speaking, there is an English language test requirement that needs to be satisfied by the migrant who wishes to apply for a spouse visa. This is currently a minimum requirement of level A1 of the CEFR or above. In addition, myself, Raheela Hussain, Principal Solicitor of Greenfield Solicitors. The show is live and I would invite our callers to call me on 0208 808 0693 in order for me to answer any immigration questions that you may have. Now, this evening's subject is on appeals, immigration appeals. I appreciate we're getting a lot of calls this evening, so I'm very sorry if you can't get through to the live show this evening, but you can give us a call at Greenfield Solicitors if you'd like to book an appointment with myself on 0208 884 1166. Now, I believe we have another call, so I shall take that. Good evening, caller.
Good evening.
Hello, madam. Please go ahead.
Hi. I have a question. I'm trying to find out what the process is for my daughter.
Sure.
I've got a Tier 1 general visa.
Okay.
In the process, I got married, and my husband is not in the country, but I had my baby here. What would be my baby's status?
When does your general visa expire, Tier 1 general visa
It's not expired. I'm still on it.
When does it expire?
next year, April.
Okay. Well, what you can do is make an application for your daughter to become a dependent on your Tier 1 General visa. So you simply fill in an application form, a PBS dependent form, which is quite easily obtainable on the Home Office website. You complete that application and you can submit it to the Home Office. Obviously, they'll ask you for certain documents such as birth certificate and so forth. And then you can submit that along with the relevant Home Office fee, and then they can endorse your daughter with also a Tier 1 General dependent visa, which will expire in line with your own visa, okay?
Okay, now that's one part of it. The only problem I've got with that is, isn't it that when I become, because the next phase for my application will be me applying for an indefinite leave to remain.
Yes.
Right? So basically, isn't it true that once I'm on that indefinite leave to remain, my daughter automatically is eligible to get a British passport?
Well, once a parent of a child born in the UK obtains legal status, permanent legal status, such as indefinite, then an application can be made to the Home Office for registration of that child to obtain British citizenship. So under the Nationality Act, I think 1981, maybe subsection 3, subsection 1, something like that from memory, it is possible to make such an application, okay? You can, of course, obtain legal advice on that. Thank you for your call. Okay, so going back to the subject of appeals, nobody's asking me a question on appeals. I would invite anyone who's got a question on immigration appeals to please do give me a call on 0208 808 0693 in order for me maybe to give some assistance on how best to prepare for an appeal that they may have upcoming. So there are so many different immigration applications that can give rise to appeal rights. As I've touched upon, spouse visas, civil partnership, fiance visas and so forth. But other visas don't give a full right of appeal, and they are more the tier points-based system visas. Now, the way that actually works is a points-based system admin review is operational where one can argue that the decision maker, i.e. the Home Office or the entry clearance officer, failed to take in facts on the application and they made a material error when deciding a case. So for example, the entry clearance officer or the Home Office miscalculated the financial funds available to a migrant under the points-based system and thought perhaps they were under the relevant amount because they didn't calculate it according to the relevant period. So there are grounds where one can submit an admin review, which is just basically filling in a document and resubmitting it to the decision maker. And generally they do give you a decision within 28 days to say, yes, we agree with you and we will overturn the refusal and grant you the relevant points-based system visa, or no, we disagree. There is no limit as to how many times a person can apply for a visa if they are refused. So if, for example, they are refused for, let's say, a fiancé visa twice, there is nothing to suggest they cannot apply thrice or again or again. However, obviously on their record, it will show that they have been refused quite a few times because the systems now require one to undertake biometrics. So when you submit a visa application form, be it in Nigeria or Ghana or wherever, or even in the UK, the Home Office require you at the time of submission of the application to go into a post office or the VFS centre abroad in order to undertake the fingerprints for that migrant. This helps with fraud purposes and to ensure that the immigration system is fair and proper. Now, what effectively happens in the event that one appeals again and again and again, they should be very honest. They should, on each and every application they make, say, look, I was refused in 2012, I was refused in 2014. They should cite down the refusal number, which is shown on the refusal notice. The Home Office, the entry clearance officer, will be very grateful for one's honesty. There is no shame, there is no embarrassment in being refused a visa, but what is not acceptable under the immigration laws is when one is deceitful, when one seems to deliberately conceal or deceive material facts or lie before the entry clearance officer or the Home Office. I would not suggest that anyone do this, because when you do lie, when you do disguise facts, when you are not honest, and when one is caught out by the system, then effectively under paragraph 320, subsection 7A of the immigration rules, it is possible for any future application to be denied for a period of 10 years. So one could be banned for a period of 10 years in that they cannot make any future immigration application to the Home Office or the British Embassy as almost like a penalty because they chose to lie or conceal facts and so forth. So always be honest, always be forthright. If in doubt, get firm, proper legal advice. Now, it's important also that I highlight a problem that we face with clients who come to our firm in the sense that they have been to many other lawyers or OIC regulated advisors over the course of their immigration history. Many have been here for many, many years, and then they find Greenfield solicitors through recommendation or on the internet or indeed through our show on Ben TV. And we assess their work and we assess their cases, and we note sometimes the work that was done for them by their previous legal advisors was of an arguably poor standard in that it failed to address their immigration history properly or did not argue a case properly. And had it been well presented, well prepared by their legal representative at the time, then the person sitting in front of me would not be sitting in front of me because they would have obtained legal status, be it discretionary or indefinite or British, many years earlier. In practice, I can tell you the way it works is you get what you pay for. So you will find that there are many people offering immigration advice and legal representation, and they will offer migrants a very, very attractive fee to undertake immigration applications or appeals. But one should not think, okay, this fee is the main reason why I wish to use this particular advisor in my application. Rather, the person should think to themselves, no, this person, this advisor who's speaking is knowledgeable, understands my problem. I feel I have the confidence in them. I feel they show me the knowledge and the ability to undertake this application to the level it requires in order for me to try and get the best result in my immigration case. And sometimes you end up paying more for a more experienced practitioner, but ultimately, I think you would agree with me, if you were to get the legal status in the UK, any investment that you pay to that advisor would be more than worth it. So please do bear in mind, do not go by price, do not go by somebody who just gives you false promises. Look at your legal advisor, read about them, check if they are regulated by the Solicitors Regulation Authority. You can do this by calling or going on the Law Society website or the Solicitors Regulation Authority website, or by contacting the OISC. OIC, I should point out, are non-solicitors, so they are not qualified solicitors. They are legal advisors who are able to provide a level of legal advice. However, solicitors have the ability to provide a full and in-depth and an advanced knowledge of legal representation all the way up to the High Court, as this is the qualification we have obtained in order to practice law fully. So, what I'd like to also speak about is with regards to another popular question. People call the firm all the time and they say, look, you know, I want my uncle, I want my mother, or I want my father to join me in the UK. They live in Zimbabwe. They're quite old. I want them to come to the UK. I want to look after them. And the way the immigration rules focus on in this respect is since July 2012, when Conservative government came to power, they amended the immigration rules substantially, and they have effectively implemented a system where ideally one's parents or dependent relatives need to be over the age of 65 in order to firstly apply for a dependent visa to come to the UK. And I will come back to this subject as soon as I take the next caller. So good evening, caller, how can I help you?
Good evening. Please, I made an application 2012 on residence permit, and it was refused. I went to the upper tribunal, which I never responded to, and I closed the application. I have a son who will be 7 years old by June. So I don't know if I make any application now, will it be valid?
Yes. So you said you made an application for residence permit. Just to confirm for our viewers again, that's under the EA regulations. That was refused. It went to the upper tribunal. You said you didn't get a response, but you have a child who was born here and is going to be 7 in the next couple of months. Is that right?
Yes.
Okay, that's fine. And I'm assuming you have no lawful status at the moment?
No.
Okay, so thank you for your call. That's an interesting call. And the way it works is it is possible for you to submit an application under the UK immigration rules on the basis that you have a child once obviously the child attains the age of 7, and you can put this application in under the exception criteria, which is included within the immigration rules, and where it is
Okay.
stated, for example, that the child is born in the UK, is the age of 7, and has been born and raised in the UK, and effectively it would be quite unfair to expect that child to leave the UK, having formed its formative years in the UK and all its ties and associations. So it is an application, and you would be seeking to request for yourself and your child something called discretionary leave to remain in the UK, which if successful you would get for 2.5 years. So yes, I would say based on what you've said, you've not made an application like this previously. So certainly try and obtain good legal advice. You're welcome to contact Greenfields, and we can book you in for advice with regards to what kind of documents you require, how the process will work, and put in an application for yourself and your child once they attain the age of 7. And I can let you know as well that the Home Office are currently processing applications, so they give decisions once the application is lodged within about 4 months. So it's quite speedy. Okay?
All right, thank you so much.
Thank you. Thank you for your call. So back to the point of adult dependence. So the person is old 65. Now the criteria what the UK government look for is effectively, are the dependent parents elderly? Are they, obviously they're elderly, are they ill? Are they disabled? Is there some sort of really exceptional circumstance which makes their living abroad undesirable, and that's why they need to come to the UK and stay with their relative here who will take on the care and responsibility for them. So they do look for whether that person can look after themselves in their country. Maybe, you know, if there's a disability and they can't wash or care or cook for themselves, that's why it's more preferable that for human rights reasons they come to the UK and be cared for by their family member here in the UK. Now the family member in the UK again will need to earn at least 18,600 to support the dependent person who wishes to come over, the dependent family member, because the government want to be assured that they won't necessarily be a burden on the UK system if granted leave to enter. Now, what's interesting is you need medical evidence to show that that person, the family member abroad, is unable to care for themselves. And you also need to show that there's no other avenue of care. So maybe there's no other family members who can look after the uncle, the mother, the grandparent, the father abroad. And that's the reason why they're secluded and they're having a difficult time caring for themselves. You would also need to try and argue why the person based in the UK cannot send money to maybe a nurse or a carer abroad, which will provide aid for the care and the responsibility of looking after the parent or the dependent family member, because the British Embassy will look at, well, what other avenues are available to this person rather than us grant them a visa to come to the UK as a dependent family member of the person in the UK. It is quite strict. In order to try and obtain such a visa. The British Embassy even have the power to use their own medical doctors to assess, or doctor of their choice, to assess the person abroad to see whether they are indeed as ill as they claim to be. So they are quite stringent on the type of medical evidence, because they have sort of clamped down on the number of dependents that they want entering the UK. Indeed, there is a very, very high British High Commission fee. Last time I checked, just pre-April, it was about £1,500 to pay for a visa application fee to a British embassy for a dependent family member. Again, I would advise, or I would suggest to anybody, I should say, who is looking to bring their adult dependent family member to the UK to obtain legal advice. Find out whether the dependent family member abroad fulfills the criteria, satisfies the relevant criteria in order to come to the UK, because it's a very costly process and you don't want to waste a lot of money if the merits of success are not good to begin with. Now this evening I noticed we're getting a lot of calls with regards to European law, the EEA regulations. The EEA regulations, I should say, are quite separate from UK immigration law and practice. The EEA regulations are quite complex in nature. They actually, the most common ones that we as solicitors and practitioners rely on, the EEA regulations, which were published in 2006, and then these were updated in 2012. Now, questions on EEA regulations are not straightforward. The reason is because solicitors will need to refer to resources. The regulations are very lengthy, there are different subsections, and when calls come in from people who have questions on EA regulations. It's not something that I as a practitioner can immediately answer because there are so many variables on EA regulations. So I would say to anybody who needs advice under the EA regulations, so for example, if your partner or your child or your husband or your wife or any family member is a European national and you seek to associate yourself with that family member to obtain legal advice, legal status in the UK, you should book legal advice in order for myself, a solicitor or any legal practitioner to sit down properly with you, spend time with you, go through your case, refer to the regulations and give you advice. Because as I said, this show is just for general information and therefore the information I provide is just that. It cannot be relied upon advice. In order for a solicitor to advise you properly, you need to have a consultation. You need to explain in depth to the solicitor what the problem is so we understand and then we can obviously advise you. Okay, so we'll also now go into something else that's quite popular, something that I get on a day-to-day basis, which is regards to children's rights. The last caller actually explained that her child is going to turn 7 in a couple of months and can she make an application under UK immigration law? Absolutely correct. Now the UK takes a very strong position and is very pro-children's rights, and they are very keen to help children to regulise their legal status because obviously the UK government understands a child cannot be penalised or should not be punished if their parent decided to irregulise their legal status or where they have become unlawful in the UK because of their parents' decisions to remain in the UK unlawfully. Now we have another caller online, so I will take that call. Good evening, caller.
Good evening.
Good evening, sir. Please go ahead.
Yeah, please, I want to ask a question.
Of course. Please go ahead, sir.
Yeah. Good evening.
Good evening. Please go ahead. I can hear you.
Yeah, my name is Yenny.
Hello, Yenny.
Yes. I have a question to ask is that
Would you like to go ahead, Yenny?
hello?
Yes, please go ahead with your question.
Okay, I should ask my question.
Yes.
Okay. My question is that
So you need to put your TV down in the background because it's slower than the live. I believe we've lost that call. So please do call in. But going back to the point of children's rights. So the UK government realises an application should ideally help and support a child. But one thing that is important to note is the government is not just going to roll over and say, okay, you know, you poor child, of course we'll grant you legal status. It's not your fault you've been here unlawfully. No. What they have recently been doing, and I can tell you in practice, we get decisions from the Home Office and they say sometimes, well, you know, the parents spent most of their life in Ghana, Nigeria, Zimbabwe, Kenya, so they can easily adapt into UK, into their home country if they were to return. The child's only spent 4 minutes in the UK, 4 minutes, I'm sorry, 4 years in the UK, and therefore there's no reason why that child cannot readapt to their life in Africa if so required to return there. You know, it's only a short period of time they're spent in the UK, but the rest of their life with the support of the parents and their family members, they could easily reintegrate back into an African country. Obviously, many of our clients seek to argue, well, no, it's not possible. Oh, we have another call, so I must take that call, I've been told. Good evening, caller.
good evening.
Hello, please go ahead.
Yeah, my question is that I came to this country with my daughter. Then I seek asylum. They grant me.
Yes.
Then after 2 years, 2.5 years, I connect with my husband. What can I do to bring my husband in?
What can you do to?
Bring my husband in to get
Your partner?
Yeah.
Where is your partner?
Yeah, my partner, yeah.
Right, I'm so sorry, sir. I've been just told, I'm very, very sorry. We've been told that this is the last call, so I'm having some difficulty hearing you clearly. If I may, please do give me a call tomorrow at the Greenfields on 0208 884 1166, as I'm unable to take your call right now, but do call me tomorrow. And what was your name? Okay, we've lost the call. So I've been told that this is, we've only got a couple of minutes left on air. So I would like to confirm that all the information that I have provided is just information. It should not be relied upon for legal advice at all. If you require legal advice, please contact Greenfield Solicitors on 0208 884 1166. Thank you for watching the Legal Hour with myself, Raheela Hussain of Ben TV.
In our country.